Caroline, can you let me know if you can hear me? I can't seem to start my video. That's okay. When I hit the start video button, it says it's disabled by the host.
So our producer will manage all of the recording, but she should be able to turn on your camera in just a moment.
Okay.
Give us just a minute to see if we can sort it out.
Sure.
My camera's not going through my computer display.
You're in it yourself, right? You're not in as you're not in as financial.
No. And I'm getting the same thing. Okay, it worked now.
No.
There we go. I can see you now.
Great. Are we all set on your end then?
Stephanie, are we good? Yes, we are good.
Okay. We will go on the record then. The time is 6:03. This is the hearing for Deschutes County file number 247-210000756-CU, a conditional use request to establish a new single-family dwelling in the forest use zone. My name is Tommy Brooks, and I am the hearings officer in this matter. We are holding this hearing in part through electronic means. So before we turn to the particulars of the hearing, I want to turn things over to Ms. House to describe how that electronic process will work.
Thank you, Hearings Officer Brooks. For the record, my name is Caroline House. I'm an associate planner with the Deschutes County Planning Division, and I'm going to share my screen here. So bear with me for a second. And okay. So as Mr. Brooks just mentioned, the hearing tonight is for a conditional use request for a new single family dwelling in the forest use zone. I'll begin the hearing by explaining how participants joining us via Zoom and members of the public can testify tonight. Apologize, but my PowerPoint just went away.
I was still showing.
Oh, it is? Interesting. Okay. Okay, I think it's back. Okay, it's not letting me progress. Here we go. So after my Zoom instructions, I'll turn the hearing over to Hearings Officer Brooks for his hearing instructions. I'll follow with my oral staff report, and the applicant will make their presentation, and then the public will be invited to testify. The applicant will be given an opportunity to present any rebuttal testimony, and staff will be afforded an opportunity to make any closing comments. I want to note, should the county's internet connection be interrupted, we will attempt to get back online as soon as possible. If that happens, please give us a little bit of time to reactivate the public hearing. And if for some reason your own internet connection, or if you're attending via phone, if you were to be dropped, please join back using the same link or phone number that you called in on. So for Zoom participants, there are two categories that you'll fall into, either a panelist or an attendee. As a panelist, your audio and video will be recorded. I note this because you may want to confer with your legal counsel, and you may want to mute your mic, and I'll go into more details on how to do that. If you're not a panelist, you're an attendee, and your audio and video will not be turned on. Our producer will manage that. And I want to note that it's important to note, if you're wanting to testify tonight via Zoom, it's important that you are promoted to a panelist so that we can record your audio and video. For those of us joining Zoom, you'll note a button for your microphone in the lower left-hand corner of your screen. I point this out because, as I mentioned before, you may want to confer with your legal counsel or your client. You can use this button to mute your microphone so that your conversation is not recorded. And next to this button, you will see a button for a video as well. So again, you can press this button if you'd like to black out your video, and this may be helpful if you want to confer with your legal counsel or your client and have the screen blacked out. So at this time, I'm going to ask anyone joining us via Zoom, if you wish to testify, please press the raise hand button in the bottom center of your screen. One at a time, I'm going to ask our producer to elevate each person raising their hand. Once you're elevated to a panelist, I'll ask you whether you intend to testify in support or in opposition to the applicant's proposal. And Stephanie, I apologize, I can't actually see anybody's hand, so I'll just let you.
Hodge and Chris Kovac both have their hands up.
Okay, so I'll start with Mr. Kovac.
I'll be testifying in opposition.
Okay, thank you. Hodge and Deborah Kerr, you're the applicant, so you'll be afforded an opportunity to testify, but if you have any questions, I guess go ahead and promote them in case there's any questions.
I'm sorry, we will be joining.
Okay. And I didn't look like anyone's attending via phone. Okay. I do want to acknowledge that we have some participants here in person that will be testifying, and I'll defer to Hearings Officer Brooks on the order receiving testimony between those in attendance in person and remote. So Hearings Officer Brooks, if you want to circle back with me, I can give you their names if that's helpful. Let's see, with respect to oral testimony, the hearings officer and staff are responsible for ensuring a respectful and orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. In addition to oral testimony, you may want to submit written testimony at the hearing. If you're in person, please submit your written testimony to me prior to beginning your oral testimony. If you're participating via Zoom, you can submit your written testimony via email. My email's on the screen. It's my first and last name. So caroline.house@deschutes.org. Just keep in mind that any submittal more than 20 pages in length that includes color figures or needs to be printed on a sheet size larger than 8.5 by 11, you'll need to also submit a hard copy. And I guess at this time, I'll also acknowledge this afternoon, I did receive some additional testimony from Mr. Kovac, and Comments were submitted by the Oregon High Desert Museum. Those have been uploaded to our ACA Oregon e-permitting website, and they're in the paper file here as well. So at this time, I want to confirm if there are any objections to the format of the hearing using Zoom. If yes, please use the raise hand function. All right, seeing none, I'll turn the hearing over to Hearings Officer Brooks.
Okay, thank you, Ms. House. Just to reiterate, although people are appearing virtually, we are following the normal hearing procedures, and I will provide sufficient opportunity for everyone to participate at the appropriate time. As you can tell from the little dry run we just did, sometimes there's a little bit of delay as people get elevated to a panelist. So just ask for your patience as we work through that process. For those of you who are testifying, please begin your comments by stating your name and address for the record. It'd be helpful to me if you would spell your name, even if you think it's simple. This application is being considered through a quasi-judicial process. As such, I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria that are relevant to this hearing were identified in the public notice announcing the hearing. They're also set forth in the staff report. The public notice and the staff report are posted on the county's website, and they're available directly from staff upon request. It's important that you direct all of your testimony to the standards and the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I do urge you to explain why the criterion must apply and to do so with specificity so that other participants can respond and so that I can address that issue in my decision. The failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. If you're not familiar with the Oregon land use laws, we refer to this as the raise it or waive it rule. Although the failure to raise, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail that allows me to respond to the issue in my decision precludes any action for damages in the circuit court. As I just noted, I do serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant. So to that end, I'll state for the record that I do not have any relationship with the applicant. I have communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any ex parte contacts to disclose. The hearing will be conducted, I think we just went over this, but in the following order, which is that the staff will deliver the staff report. The applicant will be given an opportunity to come up. We will then call on those in favor of the application other than the applicant, followed by those opposed to the application. The applicant can then give rebuttal, and if needed, we'll have additional comments by staff or questions from me. Ms. House, to answer your question about the order, I think since things are working fine electronically, I would like to go ahead at each one of those steps. We'll take the people appearing virtually first, then followed by anybody who's there in person. But still within the same order that I just outlined.
Sorry, Hearings Officer Brooks, I just want to acknowledge that Tia Lewis is here as a representative of the applicant.
Okay.
And she would like to present first on behalf of the applicant.
That is fine. Yes, absolutely fine. All right. So before we begin, does anyone wish to either challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter? And for those appearing virtually, it would be the same by raising your hand so we can call on you.
There are no hands raised for Zoom participants.
So with no objections there, I will turn it back over to you, Ms. House, to deliver the staff report.
So I just prepared a brief staff report tonight, and I'll just start by identifying the location of the subject property. So it's at 59770 Scale House Road. The property is zoned forest use F2 and is also located in the destination resort combining zone. As we've mentioned several times now, the applicant is requesting conditional use approval to establish a single family dwelling in the forest use zone. The requested dwelling type is a template dwelling. And on the right-hand side of the screen, you'll see the proposed location for the dwelling identified. So in my staff report, there were several issue areas that I've asked the hearings officer to focus his review. I'll briefly review those now. So the first is, were there any procedural errors associated with the posted notice requirements? Secondly, has the applicant appropriately described all forest practices in the surrounding area? Third, has the applicant demonstrated the proposed residential use will not significantly increase the cost of accepted forest practices on the nearby federally managed lands? Fourth, is an alternative access route required to ensure the proposed residential use will not significantly increase fire suppression costs or risk to fire suppression personnel? And if yes, what areas need to be improved and maintained? And related to that, if it's needed, do those alternative access routes need to be improved to the road standards described in the forest use zone? Number 6 is, has the applicant provided proof of a long-term road access use permit or agreement? And if yes, does that agreement or permit demonstrate the necessary maintenance agreement is in place to ensure the access standards for the forest use zone will be met? Number 8 is, can the applicant's 160-acre template drawing be relied upon for the template test analysis? Number 9 is, do the properties identified as Lot 6 and Lot 7 by the applicant meet the requirements for the template test analysis? Number 10 is, has the applicant demonstrated the proposed building envelope for the dwelling will have the least impact on nearby or adjoining forest lands? And lastly is, has the applicant demonstrated the proposed building envelope will minimize the amount of forest lands used to site the dwelling? And with that, that concludes my oral staff report, and I'm available for any questions from Hearings Officer Brooks.
Thank you. I do not have any questions for you at the moment, so I think best we just move on to the applicant's presentation.
So Tia, do you want to?
Good evening. Thank you. I'm not on the screen or anything, right? Or on camera?
You actually are.
Oh,
You
okay.
are. I can see you.
It's not broadcasted here in the room, but yes, you're being recorded.
Got it. Okay. Thank you. Good evening. Thank you. My name is Tia Lewis, and I'm the attorney for the applicant. I'm a shareholder at Schwabe, Williamson, and Wyatt, and I've practiced land use law in Deschutes County since 1993. So about the time that some of these deadlines in these applications started. I thank you for the opportunity to present at the hearing and give additional evidence and testimony in support of this application. I will go briefly over the procedural history. My clients do want to speak, and so we will try to make it quick because we know we have some other folks that want to talk tonight, but I do want to talk a little bit about the application materials as they exist in the file, so that hopefully, I know there's a lot of them and a lot of them are duplicative. And so the first application that was originally approved by the county in 2015 was prepared by Liz Fancher, a local land use attorney here. And it was a very detailed application, and Liz is probably, I think, the statewide expert on a lot of record analysis. And so Liz went in great detail to describe the lots under the template. And that application was resubmitted in this proceeding in August of this year as the initial materials submitted in support of this application with Liz's blessing. Liz is retiring, otherwise she would be representing the applicant in this particular proceeding, but nevertheless, she called me and asked me to help them with it. Because the law had not changed, the applicants were instructed to just reapply once their permit expired, and that's what they did, was they resubmitted the same materials. But they did, receive the incomplete letter despite no change in the law. There have been changes in the evidentiary standards. There's been additional case law that has come out. And so the county submitted the incomplete letter, and I, on the applicants, at which time the applicants hired me. And on their behalf, I submitted the response to the incomplete letter dated October 21st of this year. And so the difference between the materials in those applications are, again, some of them are duplicative. The original application refers to exhibits, and there's a number of exhibits submitted with that application and throughout the application process. Because I was trying to distinguish the additional evidence, the supplemental evidence that we submitted in support in response to the incomplete letter, I called our submissions attachments. And so the attachments on to the October 21st, 2021 letter are the new evidence that we submitted in response to the incomplete letter. And again, some of it is duplicative, but it's some of it is reconfigured in a way that made it more understandable to me. Everybody looks at things a little bit different, and Liz and I went over her explanation of the lots under the template, and she described that to me, and so that's sort of reworked, and I'll go through that briefly. So the first evidentiary piece that we submitted in those materials, it's actually included within the materials rather than referenced as an attachment. It's on pages 3 through 6. And what that additional evidence is an analysis of the farm and forest lands in the vicinity of the subject property. And it includes a color map. And it includes all of the zoning categories surrounding the subject property. It goes out a couple miles. And it talks about what the farm, where those lands are in the vicinity of the subject property. And then it also includes a discussion of what accepted farm and forest practices are within Deschutes County as described by LUBA. And then it also includes an analysis of the actual farm and forest practices occurring within 1 mile of the subject property. And an explanation of why this proposed dwelling will not impact those practices. I'm not going to go over exactly what it says, but that's the gist of the evidence. And the second evidentiary piece we submitted in that letter is an updated wildfire mitigation plan. Again, that was in response to the incomplete letter. The wildfire mitigation plan was prepared in 2015. And since that time, the county has required some additional evidentiary findings in these plans, as well as it provides some additional proposed conditions of approval and defensible space treatment. So that is identified as attachment 4 in that October 21 submission. The next item, attachment 5, is the order of the Deschutes County Board establishing the annexation of the subject property to the Rural Fire Protection District as of 2015. And my clients will testify that they have been paying those assessments since that time. The fourth, I guess, or whatever number I'm on, piece of additional evidence under that in that submission is the title policy. That's identified as attachment 7, and that is ensuring the subject property for access. That title policy was obtained just recently from AmeriTitle with full disclosure of the opponent's claims regarding the access issues, and all of those documents have been raised in the 2015 matter and are public record. The next item is the attachment 8, and that is an on-site productivity assessment prepared by a professional forester demonstrating the productivity of the subject property at less than 50 cubic feet per acre per year, consistent with the soil mapping category for the property. Next is a certification, that's attachment 9 from our surveyor, that the template was prepared to scale and centered on the subject property, and that is verified with his surveyor's stamped drawing. The final attachments 10 and 11 are our template drawing. It's the same drawing and the same lots that are under it, but I relabeled them to make it easier to understand. Liz is a lot of record expert, and the way that she explains things is very detailed, which is good, but I needed to understand them in a simpler way. So I just relabeled the evidentiary documents and the lots under there, because the way that they were called out as parcel 1 of partition plat was confusing to me. So they're labeled lots 1 through I believe it's 7, and then showing how we can get an additional ones if we really drill down on the lot of record analysis. And then lastly, in that submission are the conditions of approval that the applicant has proposed and is agreeable to, and those conditions are shown on pages 17 through 20 of that submission. And those are based on recent template dwelling decisions that have been issued in Deschutes County, including Lahodney and the Vargas decision, both of which contain some of the additional conditions the county has been requiring in these types of applications since the original approval in 2015. So beyond that, I'm not really going to go into in a great detail orally, because this is really just a evidentiary matter and all of the documents are in the record. We believe there is substantial evidence to issue findings in support of approval. However, I would like to really address any questions that the hearings officer may have either now or at the end. I would like to reserve opportunity for rebuttal, obviously, and then I do have my clients that would like to speak.
Okay.
Thank you.
Certainly, I'll give you the ability to come back up for rebuttal. I think one of the questions I have now, and I might have more when you come up on rebuttal, but for the access on the road, the way I've understood the application and the way it was presented in the staff report as well is that you're relying on both the plat that dedicated the road for public use and the easement. Is it your position that you need both of those in order to show road access to the site, or is the dedication and the partition plat sufficient?
We believe the dedication in the partition plat is sufficient, but we were, prior to this hearing, had not received a definitive answer as to whether Deschutes County believed that was sufficient. If you notice in the email chain, the answer was less than definitive in the 2015 decision. And so Caroline reached out to the current road department, and the answer is far more definitive now than it was previously. So we've been submitting both into the record, but the partition plat certainly solidify, and the county's reliance on that certainly solidifies that as a public access road, which is what the title company relied on as well for the title policy.
And I guess the only other question I have now is sort of going down the list of issues that staff sort of, I guess, said they would like to make sure that I address in the decision and maybe need some more attention. I think the only ones that you didn't cover in your opening comments were kind of the last couple about the location of the envelope for the building and whether or not it's has the least impact on agricultural lands or minimize the amount of forest lands. I heard you say that the material's in the record, but are you relying on what's in there now? Or are you or your client going to address that during your presentation?
Yeah, well, absolutely. To the extent that the evidence in the record doesn't sufficiently address that, we will address that. I understand that the opponent will be asking for the record to remain open, so we will submit additional, at a minimum, additional argument pointing to evidence in the record and possibly additional evidence if necessary, making sure that we have those bases covered. It's a very small parcel, so we didn't do an alternative site analysis in the sense that that we have done for 300-acre template dwelling parcels or 40-acre template dwelling parcels. We measured the setbacks, and it's also not significantly different topographically throughout the site. So I think that based on the description of where the building envelope is located, we should be able to draft proposed findings demonstrating compliance with that criteria. But to the extent the record remains open, if necessary, we will submit additional evidence on those points.
Okay, thank you. And we can address any extension about the record if and when a request is made. With that, I don't have any additional questions for you if the Kerrs want to go now.
Thank you.
Can you hear me?
Yes, can hear and see you.
Okay. So excuse me for being a little nervous. This is my first rodeo on this one. As Tia mentioned earlier, we originally submitted our template dwelling application in 2015 with Liz Fancher's help. I did not realize what a big process that was and how expensive that could be, but what it required to get that done and approved through the help with Liz. I truly believe we were able to get all the different criteria taken care of. And at the time, the Wind Lakes raised some comments about our application, and we were able to, the same ones that have been basically raised again today, we were able to address all those. And the county planner at the time felt that we adequately had responded to all the issues that were brought up, and that we had met all the criteria, including the fire annexation, like Tia mentioned. We were able to meet all that criteria, and we were able to get an administrative decision for the approval of that. After that, we began to meet with architects, septic contractors, well drillers, and the Wind Lakes family, the neighboring property owners, threatened us with legal letters from their attorney that we were to stop what we were doing because we were, and that they could arrest us for trespassing on our property. But we were hopeful to kind of come to an amicable resolution with them. However, they made it clear that they truly didn't want us as neighbors. And that's kind of why we're here, I believe. Some time went by and we filed for an extension, and we worked on some other items on our property, including brush clearing, brush mowing, fire, and we also did a prescribed fire along with our neighboring property. The High Desert Museum also did a prescribed burn, as all part of to be in compliance with the current fire management standards. But what happened is I ended up having a job change, moved over to the Portland area, and in that process and time, life happened and COVID happened, and lots of other things took over. And unfortunately, to our devastation, I guess, I'm not sure how I say that, but our application expired. And we didn't realize that. We came back to the county and tried to go to the next step and found out that we had the dates wrong and that our application had expired. So with all that, we resolved to move forward and reapply. And we learned and understand now the reasons for the updated criteria and reasoning behind it. It all makes sense with recent fires and all the other legal actions and things that have happened on other template dwellings, that the new criteria would be a little bit more, there'd be quite a bit more to do. So we rehired the same fire management person we had hired before. We updated his information. We rehired Liz to help with Tia. We paid for some additional support from her along with Tia to get this going. And we also updated our surveying, and so excuse me. So as we went through all that, again, the wind links raised issues with all of our contractors, again, threatening us, harassing them, telling us that they were going to arrest people, and we got a letter from their attorney that that they were trespassing and such. So it's clear that this was not really about that their reason to contest this wasn't about the issues that were already approved, that this was more about not wanting us as neighbors. So at a large, anyhow, we went through the process, and we've worked diligently to provide all of the information to kind of get the updated criteria met. And we've spent quite a bit of money, and I think my wife wanted to add a few things in there as well.
Yeah. Hi, sorry. So did you want, I know you requested maybe starting with the name and spelling and address. Is that what you would like me to do?
I think for you guys, I have that information, and your name is hopefully printed on the screen. So I've got that. So you can skip that part.
Okay, thank you. So the last part I just wanted to just kind of, address is just the fact that, Hodge and I are just everyday people. We're not attorneys. We're not lawyers. We're just kind of hoping and asking for some common sense to be considered. I'm not sure if there's a place in all of the criteria where that is considered. However, we feel it's important to stress that we are kind of feeling like a little bit of the underdog here. We are merely just requesting a reissue of our original template dwelling for a very small 6-acre parcel surrounded by several other homes and the High Desert Museum, and in no way comparable to these other case laws and cases where requests are being made on 300+ acres. And we feel that had the wind links not opposed this application, I feel pretty confidently that another admin decision of approval by the county would have been issued again. And we're just kind of hoping that, you'll look at where this actual property is, what's around it, and kind of look at how much more we've invested into getting this. And again, it's just kind of being drawn out by the opposition. I don't know that, I feel like we've answered, all the things that are of concern, like the easement, even going to the point to getting a title, a company to ensure that for us. So about it, I believe. Thank you.
Thank you. I don't have any questions for either of you. So we can move on to anyone who wants to testify in support of the application. And if there are multiple people, I would take the anyone appearing online first.
So there are no hands raised online, and no one in person is proposing to testify in support.
Okay, thank you. Then we can move to any testimony in opposition. And it sounded like Mr. Kovac had signed up for that and was also appearing virtually.
It looks like Deborah and Hodge Kerr just raised their hand. Can we elevate them again to panelist? Okay, so Mr. and Ms. Kerr, if you just unmute yourself, we'll be able to
Yeah, I apologize. I didn't meet, I know that the High Desert Museum had submitted a letter, and
In
is that,
favor.
is that something that it can be read or discussed at this point, or is that not?
My understanding is, if I heard right, that that was submitted and is in the record. So
Oh, okay.
I haven't even want to read it.
Okay. All right. That's all. I just want, because that I know that I just,
That was in favor. We just want to make sure that was noted.
It sounds
Okay.
like sounds like it's in the record. I didn't see it this afternoon, but it sounds like maybe it was uploaded later. So I'll make sure to make sure that I get a copy of it.
Thank you.
So do you want to, is Mr. I think Mr. Kovac was the only one that I heard that signed up in opposition. Is that correct?
Yeah, our producer's promoting him now, a panelist.
I'll be patient.
Are we good?
I can hear you and see you.
Now you can't. Now you can. Thank you. Good evening, Mr. Brooks, Ms. House. Thank you for giving me some time tonight. I represent the Winlinks Ranch Trust. My address here in Portland is 1331 Northwest Lovejoy, Portland, Suite 935, and that's 97209. As I said, I represent the Winlinks Trust. I'm not going to get into personal issues like we heard from the applicant. This isn't about personal issues or who likes who doesn't. It's about whether or not the applicant meets the criteria, whether they've satisfied their burden that the code clearly places on them to produce substantial evidence to show that they've met all of the required criteria. That's the only issue. There are some issues I'm not going to talk about. One is impact on adjacent forest lands. Mr. Winlinks is there. He will testify after me. His family's been in forest practices for many years. They know much more about it than me. They're going to talk about that component. I'm not going to talk much about soils. We have a soil consultant. Mr. Winlinks got a report just today from them. He's going to introduce that report. I will briefly touch on it, but it's going to be he and the consultant that carry that. I'm going to primarily address the easement issue, the access issue, and then the template test, the lot of record issue primarily. Before I get going though, here in some jurisdictions, including my own, we have a limit on testimony time, and so I allocate my time properly. Is there a hard limit?
I have not set one yet. I reserve the right to do so. I think given the relatively few number of people that have signed up, I'm inclined not to set a hard limit. I guess I'll just note for you that the applicant went about, 25 minutes or so. So I would try to strike some balance there.
Yeah, I don't, no intention of going on and on and on. It's not my style. I just don't want to, if there's a 3 or 5 minute limit, yeah. I want to allocate my time appropriately. So on access, the first issue is, I think whether or not the easement is necessary has been determined. And I read Mr. Samuel's report and the staff report to say it is. Because what he's clearly saying, I'm looking at his memo, his email that I should be in the record because it was sent to us. And it's clear that the owner's affidavit on a partition, which everybody in land use knows, you dedicate property shown on the plat. And in context, what he's saying is the roads shown on the plat were dedicated. And then when he goes back to his conclusion on the last page, Mr. Samuel clearly shows that there was a section of the Scalehouse Road dedicated, and he shows exactly where it is in one color, and it's only within the partition plat, because that's the only thing the county could require. They can't require dedication of property outside the plat, and they didn't in this case. I've read the decision. Then he shows another section where there was a right-of-way that was retained, and that I think goes back to something in my letter, this 1980 or 81 dedication that the Brooks Scanlon Company recorded that created some public access over the middle section. And that went right out straight to Highway 97. So that was public access too. And that's been retained. And then there's the third segment, which we call the northern segment that goes out to Knott Road. And that was abandoned by the state and it reverted to Brooks Scanlon. And then when the Windlinks acquired their property from Brooks Scanlon, they acquired it free of any encumbrances. There was no right of way over it. And I think that's what Mr. Samuel's saying. So the substantial evidence in the record from our perspective shows unequivocally that without the 94 easement, there is no access other than the dedicated access directly out to Highway 97. Now, there's a reason the 94 easement was put in the record, I think, and that is when Highway 97 was widened, that dedication, although I think it exists on paper, you can't use it. So there's no direct physical access for the applicant out to Highway 97 anymore because the Highway Commission took that away. And getting to the title report, I think that's all the title company was saying is based on the records, there's probably some legal access. They didn't come out and say, we ensure that you have the easement. And I think it's just a little misleading to suggest that that's what the title company said. They would never say that. They don't get that detailed. And furthermore, they can't decide legally whether there's access is required or not through that easement or what that easement gives from an access right. They just ensure title. They're not an arbiter of legal rights under an easement. So we believe the record is clear the easement's required. Without the easement, there is no access, long-term access under the code. So we get down to, is that 94 easement substantial evidence that the subject property has access? And that's really critical. This application involves a piece of property, a parcel that was legally created in 1941. No question about it. It was a Brooks Scanlon deed to the Highway Commission in 1941. And the applicants have to rely on that existing previously created parcel because they need it to be allowed a record. In other words, they can't go out and create another one. The minimum parcel size in this area is such they can't go out and create another small parcel out of the parent parcel, tax lot 4412. So they need that independent legal status for tax lot 99. I'm going to refer to it that. It's 600 now, but when all this was filed, it was tax lot 99. And so if you read the easement on its face, it is very clear. It says that the easement benefits tax lot 4412, a specific piece of property. And if you compare that to the application seeks approval of a dwelling on tax lot 99. When you apply the rules that you have to apply in construing an easement, you have to say, on the face of those two documents, is there substantial evidence that there's an easement that benefits the subject parcel, that parcel created in 1999? Clearly there isn't. Now, the applicant, and I've worked a lot with Liz Fancher, and I respect her as a land use lawyer, and I agree with everything that Ms. Lewis said about it. They tried something kind of clever, and they did this strange lot line adjustment that I've never seen ever, where they essentially took tax lot 99 and moved it 2,000 feet to the north and put it in the northwest corner of the former tax lot 4412, and claimed that because now they moved that lot up to that area that formerly benefited from the easement when it was tax lot 4412, somehow mysteriously they can create a new grant for a parcel that didn't exist. The grant never existed. The grant in 94 went to a specific property that excluded tax lot 99. And that's important. It specifically excluded it from the description of the benefited property. And the Kerrs, the grantees at the time, they owned both parcels. They owned tax lot 99 in 1994. So you have to conclude that they knew they didn't get an easement to it. They specifically excluded it from the benefited property. And this lot line adjustment and relocation, there's no authority for their position, no legal authority that you can expand the scope of an easement to a property that was not formally benefited simply by moving it around. And I think there's, as I put in my letter, I think there's some indication that the applicants know that, because then in Liz's letter of February of 2015, she notes that the easement allows subdivision of tax lot 4412, which it does. But the problem with that theory is they didn't create tax lot 99 from a subdivision of tax lot 4412. It already existed and it didn't benefit. So again, it goes back to, you couldn't do what they wanted to do and and fall within the easement. You couldn't create this small parcel in an F2 zone through a partition. So they had to come up with some creative maneuver using a property line adjustment to move it and then try to come up with this convoluted argument how it still now benefits from this easement. And so we think just on the face of the documents put in context, you have to find that there is no long-term access from Knott Road to the property. Whether they can recreate access out to the dedicated area on Highway 97, that's not our issue, but they don't have the right to use the easement. Now, if you get into whether there's an ambiguity and you look at extrinsic evidence, that's where the case really falls apart, because we've given you some communications from the Kerrs in 2013 when they were anticipating this relocation, where they admitted on 2 occasions, we have this extra tax lot, it doesn't have an easement. We're going to relocate it, and we need you to give us a new easement, an amended easement, so we do have access. So if you consider that substantial evidence, there is no evidence to support the claim that this easement benefits tax lot 99. So how does that go? I think it goes like this. Before they can seek approval, the applicants need to go get that legal right determined. It's not that the evidence that is in the record is not sufficient for the hearings officer to say, I'm going to approve it and make somebody disprove it, make the Windlinks go to court and prove they do not have it. I don't think there's enough evidence to get to that point. And if there's any question on this, I would encourage the county to bring county counsel and get their opinion on this, because I'm pretty sure they're going to agree with me on that. So access, we think, kind of kills the whole deal. But even if there were access, I'm going to move on and talk about the template test, because here we think the template test, for a couple of reasons, is really flawed. One, the soils capacity, you're going to hear from Mr. Windlinks briefly, and he's got an expert consultant's report that shows that the soils are capable of producing well over 50 cubic feet a year. That's very, very important, because if any shoots down the evidence from the applicants on that. And that's really important, because if it's over 50, as you know, you got to have 11 lots, 11 other parcels or lots that existed in 1993. They don't even try to identify 11. They've got 7. So if the hearings officer agrees that the evidence from our expert is substantial evidence that soils are capable of producing more than 50, it ends there. It's another fatal flaw, because there aren't 11 parcels identified. So that gets us to, well, what if you reject that testimony and that expert information and say, well, they only need to show 7. Well, we've addressed that too. So the first lot of record I want to talk about is lot of record 7. The applicants first, they have 2 alternatives. One template shows lot of record 7 being 1 lot of record, and one showing it being essentially 3. And that relies on this 1910 deed where the railroad company got some form of property right for locating a trunk line on 50 feet either side of a existing or to be constructed line. That's all it said. It didn't describe the property. It just said we got 50 feet on this side and that side of a line formed by a trunk line that exists now or may exist later. We've given you the law on that. It's pretty clear, the Capilelli case. That deed, even though it's a warranty deed, based on the description of the property interest and the use described, it's deemed legally to be an easement or a right-of-way. And in either case, it's not a separate, distinct parcel that could ever qualify for a lot of record. And therefore, it can't create a lot on either side of it. Because if it's just right-of-way, the county policy is steadfast. Right-of-ways don't create new tracts that separate property. So if you look at the creation of that railroad right-of-way, it was never a parcel. It was never described as a parcel. It was never conveyed as a parcel. It never showed up on tax maps as a parcel. There's actually no evidence. We don't believe there's any evidence that exists that there was ever a parcel. And furthermore, in 1979, the railroad terminated it with a quitclaim deed. And I think as practitioners in this area know, one of the common ways to terminate an easement is using a quitclaim deed. And the quitclaim deed is similar to the 1910 deed in that it doesn't describe a specific property that's being reconveyed. It just says we quit claim any interest that we have over these two large government lots, which is consistent with them just saying, to the extent we have an easement over there, we don't need it anymore. The railroad was never built, I guess, and we're terminating any interest we have. So we believe that substantial evidence in the record shows that there was never a parcel called the railroad parcel. Lot of record 7, it could only and always be one lot of record, not 3. So then we go to lot of record 6. We've addressed this in detail in our written stuff, but lot of record 6 is this little sliver of property called the Kiever. They call it the Kiever remainder. Really what it was is, Brooks Scanlon owned all of this property in the late 70s. And in 1981, they conveyed most of the Cleaver holdings to my client's parents, the Windlings. But they kept this little strip, this Kiever strip. And it essentially became part of a strip right below it, tax lot 4313. And now in 1981, the county did have a subdivision ordinance. And there were a lot of these transactions. I'm going to get to lot of record 2 was created the same way, where people will use deeds to separate parcels without going through the partition process. And this is something I learned from Liz, is to avoid the conclusion that these were all illegal parcels, the county treated these deed transactions as lot line adjustments. And so in this context, and they looked a lot of, the one I cited in my letter was one where the intent of the parties was really instrumental in the conclusion. And so how you have to look at the Kiever remainder is this. When Brooks Scanlon conveyed the rest of the parcel to the north to my client's parents, they kept this little remainder and intended to lot line adjustment into their remaining holdings because they kept the property to the south. And they conveyed that a year later to the museum. And so the Kiever parcel, lot of record 6, through this deed lot line adjustment policy, merged. It never had a separate existence after the 1981 deed to the Windlings. So it could never be a lot of record. It wasn't created when my client partitioned their property, as the applicant's attorneys have said. My clients never got it. It was never part of their partition plat. Brooks Scanlon kept it and joined it, consolidated it into 4313. So a lot of record 6 doesn't exist, and therefore they only have 6. They don't have 7. They have the railroad parcel is just 1. A lot of record 6 goes away. They only have 6. There's another problem with lot of record 2, and this is a little more challenging, and I have to admit this. A lot of record 2 is the eastern half of 4412, the Kerrs property. And the applicant has the burden to show that they have 7 other lots or parcels in this proceeding. And their evidence is, well, we have a prior lot of record verification on lot of record 2. And ordinarily, I would agree that's substantial evidence to show that lot of record 2 is a lot of record. It's a decision made in 2013. However, the decision, and I'm going to explain this, the decision was based upon a conclusion that prior development permits granted on the museum property left a remainder parcel, lot of record 2, that qualified for lot of record status. Now, there's been a change in the law in Deschutes County. In 2016, in the Grimstad case, Luba said the policy that the county used to verify lot of record 2 in our case was so deeply flawed, it couldn't stand. It was deeply flawed. Now, given Luba's holding in that case, it is our position that for this application, that lot of record determination in 2013 is void. It's out the window. And this hearings officer and the county have an obligation to reevaluate that lot separately and determine for this case, is it or is it not a lot of record? And I think that's really important because if you look at that parcel and how it was created exactly how the Kiever parcel was. It was split off from the Ferguson tract in 1981 or 82 and conveyed to the Kerrs. That was an illegal lot division. And so you have to look at it one of 2 ways. Lot of record 2 is either an illegal parcel that can't qualify for the 7, There's got to be a legal lot to qualify, or that deed to the Kerrs in 1981 was the same as the Kiever parcel. It was a lot line adjustment. It was legal, but it affected a consolidation. And 4412, tax lot 4412, is and always will be a single lot of record. It cannot be two, as the applicant presents. So those three reasons, those three parcels go away as lots of record, and that leaves the applicant with 5 lots of record within their template. And that's we think the substantial evidence in the record only allows that conclusion. Now, we have some other information on the template test. I'm going to briefly talk about that. You could tell how this tax lot 99 was redone. It was moved 2,000 feet to the north, and it was shrunk into a trapezoid. And the trapezoid actually, I think, was designed to allow the applicants to kind of manipulate where the center was. It's a really difficult equation to determine the center of a trapezoid, but you can't do it the way their surveyor did it. We have an expert surveyor opinion in our material that, that shows. Our lights go off automatically. I hope that doesn't bother anybody. But we have an expert opinion on how you can't use the formula their surveyor used to locate the centroid of a trapezoid. And my client, Randy Windlinks, is an engineer. He found the right formula and he did it. And it puts that square, the center of their subject parcel, about 38 feet south of where they have it, the applicant has it. That's important because as the applicants present their template, it barely touches one of the Windlinks parcels, one of the ones they need for 7, just barely. Now, if you move it 38 feet to the south, we believe there's a significant factual issue as to whether that parcel is in or outside the template. And for that reason, we believe there is not substantial evidence in the record because their surveyor didn't go out and measure it on the ground. We don't know how far into the parcel they suggest their template went. And so if you accept our testimony and evidence that the center is 38 feet to the south, you're left with not enough evidence to conclude that template actually touches the Windlinks parcel up to the north. You can see it's just a very small corner. So you're going to have to evaluate that evidence, and I'm sure you will, but we think that when you look at the way the template has to be centered, and you look at the evidence of whether or not it touches that parcel, you have to conclude at a minimum there's not substantial evidence currently in the record to show that that parcel meets it. That would get them down to like 4 parcels within their 160 acre square. And then finally, we believe that the lot line adjustment that they did in 2013 really was based on an acreage test, and that's not allowed. You can get a property line adjustment, but you can't create a separate new buildable lot through a lot line adjustment. And we think that's based on an acreage test. And we think that's clearly an acreage test because they clearly used the lot line adjustment to manipulate the location just so it falls within the 160 acre template. That's an acreage test in our view. And so we believe that's an issue that the hearings officer has to decide. So I think that covers mine. I hope I did it in less than 25 minutes, and I'm available for questions. And then Mr. Windlinks is going to go. And I'll just tell you right now, we're going to keep the record open because we didn't know we'd get our consultant's report on the forest stuff today. We did get it today. We were able to get it in the record. So when Mr. Windlinks is done, we may retract our request to keep the record open. We think the evidence that we've presented here is adequate for the hearings officer to make the decision, and we're likely to just allow the hearing to close today. Thank you.
All right, thanks, Mr. Kobach. I do have one question for you to make sure I can follow. I think there was a part of your discussion about the easement that I wasn't tracking, and I just want to make sure I get it right. So the relocation, we'll call it, of tax lot 99, which is now, I'll just, for the lack of better phrase, it's sort of in the northwest piece of what was the bigger parcel. if I'm following, you're saying that the easement as it originally was issued, this is the 94 easement, excluded tax lot 99
Correct.
when it was in its old location.
Correct.
And then it went to a new location. And I understand your argument is that the easement, or I guess I'm asking, is the new location part of what was previously tax lot 4412?
It was before they had to record a new deed. Yeah. When you do a lot line adjustments, you know, you have to record a new deed. So that area now is not part of tax lot 4412.
Right. But it was part of lot 4412 as it existed when tax lot 99 also existed originally.
Right. Before the two properties were redescribed. Yes.
Okay. And so then the 94 easement does refer to tax lot 4412 as it existed when the easement was executed.
Yes.
Okay. Okay. I appreciate that clarification. I don't have any other questions for you. I think that would take us, it sounds like there's a few more. No one else online, right? That was the only one.
No, no one else raised their hand, but we do have one person in attendance in person that would like to testify.
Okay, let's do that.
My name is Randy Winlinks, Windlinx. My address is 59895 Scale House Road, Bend, Oregon, 97702. So to start out, impacts to the Windlinks Ranch Trust, which we're going to refer to hereafter as the Windlinks Tree Farm, which is basically my property along with the remaining property of the trust and my younger brother's property as well. We treat it as one contiguous tree farm. The application does not address the fact that we have an ongoing tree farm adjacent to tax lot 99. And by not doing so, they don't address the potential impacts to our tree farm. And those are covered in my written testimony. I don't feel that I need to bog down this hearing with going over what I'm going to submit in writing. But essentially, we're running an industrial operation and we have potentially a residential development sitting only 100 feet from where we basically are operating heavy machinery, falling tall trees, doing commercial mowing, which throws projectiles up to 200 feet from where we're mowing. And it's just not a good combination of having a residence and basically the activities that are associated with a residence that close to a commercial tree farm operation. The wood fiber production, which is directly related to the soils. In 2015, we submitted to Stu's Auto's soil assessment of our tree farm. At that point, it was 58.5. I'm resubmitting that because that was strictly a wood fiber production based on what Stu calculated as an overall soil productivity for our tree farm, which that same soils carries over across the fence line in the tax lot 99. That's always been our contention that tax lot 99 can produce well over 50 cubic feet of wood fiber per acre per year. I reached out to a consultant who has Creative Resource Solutions. He based his studies primarily on John Jackson's site assessment numbers that he came up with, which were just resubmitted with the application. And his determination on John's assessment was that tax lot 99 is capable of producing 85 cubic feet of wood fiber per acre per year, which far exceeds the 50. And that's included into this report as well. The other issue I have, or the Windlinks I have as well as the Windlinks tree farm, is the fire siting standards for this dwelling on tax lot 99, because the footprint of where they can put this residence within that 7-acre parcel is so broad, they haven't addressed any specific fire siting standards that basically could impact our tree farm, the Kerr's tree farm, or the public land that resides in that area. And for that, basically, before someone can basically determine the full impact that this residence is going to have on the surrounding timber production, I have an issue with that as well. Other than that, basically everything's covered in my report here, which I will submit. And if you have any questions, I'll be free to ask, please.
Thank you. I don't have any specific questions for you. Thank you.
Thank you.
And Randy, I'll take your written testimony. You have it.
So if that concludes the testimony, the applicant or the applicant's representative can come back up for rebuttal.
Thank you. Yes, Tia Lewis again for the record. I'll be brief, and I do want to talk about a post-record opening. I realize Mr. Kobach said that they would be willing to close it, but they submitted a lot of additional evidence today, none of which I've seen. So I do need some additional time to look at it and respond to it, as well as anything that the hearings officer believes needs supplemented in the record as identified by Caroline in the staff report. I do take issue, though, with the idea that the title report and the recognition that, or the title policy and the recognition that it ensures access is misleading. If you read the policy, it does ensure access. It specifically ensures access, and it is the reason that we obtained the title policy. And we discussed the access issue with the title examiner prior to the issuance of the policy, both in terms of the plat dedication and the easement. And I may have misspoken. I don't like to address things very much on the fly in a land use hearing when we have a lot of tedious documents. So we have continued to submit both the plat and the easement under the belief that we needed both of them. When I read the county road department's comments, I thought that they concluded that we didn't need the easement because the entire road was public. But nevertheless, I do continue to maintain that that easement benefits the subject property. And I appreciate the hearings officer's question in that regard, because that is exactly why the easement continues to benefit the subject property, is that easements benefit legal described real estate, and the real estate that is described in the easement is now the real estate that is included within the boundaries of the subject property. Tax lots are a legal fiction created by the assessor, and so we believe that that easement benefits our property, and we will continue to defend that. And just as the title company is not the final arbiter of access, neither is the county. And so I want to be clear that the opponent's argument requires the county, and in fact is asking you to ignore legally recorded documents. The arguments both with respect to the access and with respect to the legal lots of record. He's asking you to ignore recorded documents on their face and to interpret deeds and call them right-of-ways instead of an actual warranty deed, and to conclude that an easement that contains a legal description that describes the subject property doesn't actually benefit the subject property, and to also conclude that the intention back when properties were conveyed between property owners was really a lot line adjustment and not to create a separate legal lot by a remainder lot, which the county has determined. He's actually asking you to ignore county decisions, lot of record decisions that have been final for years. He's asking you to ignore lot line adjustment decisions. He takes issue with the lot line adjustment that was done and final in 2000 and whatever year it was, excuse me, I don't have the date right in front of me. But that's the essence of this argument and why we will address the specifics of the legal lots of record in our final submissions. We've addressed them many times before. A lot of these arguments are the same ones, but there was some additional evidence submitted tonight. And so I do want the opportunity to respond to that evidence, and we'll take some time for a post-hearing submission. But in the meantime, it's not helpful to continue to rehash the same arguments and resubmit the same evidence. And so to the extent that the hearings officer sees some things that he would like the applicant to focus on in terms of addressing, I would love to hear what you have to say about that. Otherwise, I can continue to address everything under all the criteria. Definitely the additional evidence submitted, but thank you.
All right. Thank you. I'll make some comments about sort of the record when we wrap up here. I guess just while you're up here, just to make sure, in terms of requesting that the record be left open for written submissions, do you have a proposal? We do, are you suggesting a normal 777 approach or something different?
I think that's acceptable given what I know right now, but depending on whether or not I need additional consultant review of the evidence that they've submitted from supposedly an engineer and a forester, I can't predict my expert's schedule. So I would like to say 7, 7, and 7, and then once I get back to the office tomorrow, confirm that, let's set it at that. But if I find out that I can't respond to it in 7 days, I would like to petition for an additional time frame.
And one thing I am compelled to get on the record is under the county's code, a request by the applicant to extend the record does extend the 150-day deadline. I just wanted to make sure that was stated for the record, that you didn't have any objection to that.
That's understood. Thank you.
Let me just look. All right, how about, so I think we'll wrap up. That concludes the rebuttal, and I'll have staff come back up to see if they have any additional comments, and then we'll discuss the record extension.
So at this time, hearings officer Brooks, I don't have additional comments or information to provide, but to the extent I need to provide any additional information to you during the open record period, I could do that. Okay.
Okay, that sounds good. So with that, then we'll conclude the hearing portion. Procedurally, the request is to leave the record open for the 777. I'd like to make sure I understand what those dates would be. And look, from my calendar, it looks like those all fall in December and would be the 7th, the 14th, and the 21st. Is that what you would have, Ms. House?
Yeah, so let me run through those dates real quick. I have them written down here somewhere. So the open record period for new submissions would end on Tuesday, December 7th at 5 p.m. The rebuttal period 7 days after that would end on Tuesday, December 14th at 5 p.m. And the applicant would have 7 days for their final argument, and that would end on Tuesday, December 21st at 5 p.m. Thankfully, none of those dates fall on holidays, so I think we're all clear there. I do want to note that the county's recently changed our operating hours, so our doors will start closing at 4 p.m. I'll still be working till 5, so if you want to submit anything hard copy between 4 and 5, just please coordinate with me, and I'll make sure I'm available or someone's available to receive those materials. And if it's okay with you, Hearings Officer Brooks, I want to share my screen real quick and just go over those submittal requirements.
Please do.
So all submittals should be to my attention. So Caroline House, my email is caroline.house@deschutes.org. As I mentioned before, email submissions that are greater than 20 pages include color or need to be printed on sheet sizes larger than 8.5 by 11, need to be submitted as hard copy as well. I'll also note that Deschutes County does not take responsibility for retrieving information from websites. So if there's something specific that you want us to review, you need to actually submit that material. And we don't use any personal cloud storage services to retrieve information. And just as a friendly reminder, please make sure any submittals that are submitted electronically are received before 5 p.m. I suggest not waiting to the last minute so that there's no issue with that material being received on our end. I think that covers everything for now.
Okay. I think the only other thing I wanted to raise was the way I read the county's code is I have discretion in terms of keeping the record open. I would like to stick to the 777 if we can, but I will, if there's a request during that period that it be left open longer, I will consider that request. If I'm mistaken and there's a requirement that it continue to be left open, whoever's making that request should bring that to my attention. Otherwise, I feel like it's within my discretion to either stick with the 777 or to allow an additional record extension. If there is an additional record extension, of course, any evidence that's submitted during that will all the parties will have a chance to rebut that, and I'll make that'll continue to be part of the process. Are there any other I'm going to wrap up with one more statement about that open record period, but are there any more procedural issues that need my attention tonight? Okay. So with that, we'll conclude this evening's hearing. The record is going to remain open for an additional period of 7 days for any party to provide additional evidence about the application. That concludes on December 7th. After that, the record will remain open for an additional 7 days, but solely for rebuttal evidence and argument for things that are already in the record. So no new issues at that time. That concludes on December 14th. And then after that, the record will remain open until the 21st, solely for the applicant to submit its final legal argument without any additional evidence. So with that, I think we can go off the record at 7:22. Thank you.
Thank you, Hearings Officer Brooks.